Hi, this is part 18 of the revision lecture series on arbitration. This video is going to provide a very brief guide, that is an overview to the arbitration process in Pakistan. So after watching this video, you will be able to get a very quick idea about how to initiate arbitration proceedings and what are the first and the key steps that you need to take before you can refer your matter to arbitration. Right, so the very first step that you need to take that forms the foundation of arbitration under the Arbitration Act is the agreement to arbitrate. So there has to be a mutual agreement between the parties, and that is the parties can agree if they want to, that is they can mutually agree not to submit a dispute to a regular court, but instead submit their dispute to one or more arbitrators. So arbitration is therefore based on an agreement between the parties to refer a dispute between them to impartial arbitrators for a decision. So you can see very clearly that this is why I have been saying in my earlier videos that arbitration has a contractual basis, since it is based on an agreement between the parties. So now that we know that the agreement is the very first step that you need to conclude before you can refer a matter to arbitration, so we need to know what exactly is an arbitration agreement. So as defined in section 2, subsection 2 of the Arbitration Act 1940, an arbitration agreement means a written agreement to submit the present or future differences between two parties to arbitration, whether an arbitrator is named in the agreement or not. I am going to elaborate on this particular phrase, that is present or future differences, in a moment. So for now just ignore it and focus on the definition, that is an arbitration agreement is simply a written agreement, and please focus and emphasize on the word written agreement, because if it's, for example, concluded orally, that is verbally, then that's not going to be a successful, that is an enforceable arbitration agreement. So for example, later on, if one of the parties decides not to agree to refer a matter to arbitration and the agreement was concluded orally and not in writing, then the party who does want to refer the matter to arbitration is not going to be successful in enforcing such an oral agreement. So please remember that the arbitration agreement has to be in writing in order for it to be enforceable, that is, in order for it to be enforceable in a court of law. Why? Because as we will see, there can be situations where one of the parties later refuses to comply with the agreement and they refuse to refer a matter to arbitration when a dispute arises. So in those situations, if the other party wants to compel the party who is refusing to submit the matter to arbitration, then that party has a remedy, that is that party can force the other party, compel the other party to do so. And how will that party do so? By making their written agreement enforceable by approaching the court, by filing an application in the court. So we are going to go through that particular detail in another video. For now, just remember that the written bit is a very important, that is, it is a very crucial component of the arbitration agreement. And like I said, the phrase present or future differences, I'm going to talk about that in a moment. And the very last line that I said, that is whether an arbitrator is named therein or not, that is whether an arbitrator is named in the arbitration agreement or not. So who counts as an arbitrator, who can act as an arbitrator, that is going to be the topic of another entire video. So please wait. For now, just remember that it's not important that an arbitrator is named within the agreement. Later on you will see why it's not important and what other ways there are to choose or select an arbitrator, that is to appoint an arbitrator if an arbitrator is not mentioned in the arbitration agreement itself. So we're going to come to that later when we talk about arbitrators. So one particular video will be dedicated just to the topic of arbitrators. For now, I'm going to conclude this particular part, that is what counts as an arbitration agreement is simply a written agreement to submit present or future differences. So like I said about this, I'm going to comment in a moment, to arbitration, and whether an arbitrator is named in the agreement or not is not important. Okay, so I have been talking about the fact that I will comment on the phrase present or future differences. So finally, let's get into it. See, present differences I'm going to give a very simple example. Let's say that a dispute has erupted between two parties just now, and these two parties don't already have an arbitration agreement that has been concluded between them. So in this kind of situation where a dispute has just erupted, and in this situation they don't have an arbitration agreement in place already, so what they can do is they can just conclude an agreement right away if they want to, of course, refer the matter to arbitration. So in this situation you can see that they are referring their present differences, that is their current differences, differences that are present in the moment, differences that exist in the moment that the arbitration agreement is being concluded. So these kinds of differences are obviously going to count as present differences, that is differences that exist at the time the arbitration agreement is being concluded. And on the other hand, now to contrast present differences with the other situation, that is future differences. So to understand what we mean by future differences, let's think of a very simple example, a very simple situation. So let's imagine that I enter into a contract with you regarding, let's say, the supply of some sort of goods or maybe even services. So let's say I enter into a contract with you regarding the supply of goods and services, and these can of course be any kind of goods or services. Let's not worry too much about what kinds of goods or services I am providing to you. But for instance, once we have entered into the contract, we forgot to include any sort of clause which helps us resolve any disputes that may arise between us, because because at the time we were concluding the contract, we were mutually happy with whatever we were talking about. So the pre-contractual negotiations, that is the right term for this kind of a situation. So the negotiations and discussions which were taking place before we entered into the contract were going on so smoothly. There was no dispute at all, no differences at all between us. So maybe we never thought about this possibility that a dispute may arise in the near future or in the long term between us. So because of all of this, the fact that we were in mutual agreement over other terms and conditions, so at that time we never thought of including a clause in our contract which provides us with a possible solution, that is a possible way of solving our problems if there is a problem in the future between us. Now in this kind of a situation, the parties have the option, of course, that once a dispute does arise, then they can refer that matter to arbitration by, for example, concluding a separate arbitration agreement right there and then. But what I want you to understand is that the right way of going about concluding contracts, especially in today's world when time constraints are affecting almost everybody, so in today's world the best way to conclude a contract is to not be distracted by the fact that at the present moment there are no differences between you and the other party. So that means that there will never be any differences between the two parties. So it's better to think realistically that there is a huge possibility, and even if not a huge possibility, but there is definitely a possibility that in the future some sort of a major or a minor dispute may arise between the two parties. So this is the kind of foreseeability that one has to have when engaging in any sort of business activity, of course. So in this kind of situation, the best way forward is to ensure that when you conclude a contract, in that very contract it's best to include an arbitration agreement clause as well, and that clause can, for example, have a phrase which contains something like the one that we saw, for example, that the parties agree to submit not only present differences but also future differences. And this particular phrase, that is to the agreement to submit future differences, means simply that if in the future any dispute arises between the two parties, that is, let's say you and me in this particular example, then in that situation we have already agreed mutually and happily that if in the future any differences arise between us, then we are going to refer that matter to arbitration. So this is the end of this video. In the next video, I'm going to continue talking about this particular aspect. So please watch that video if you're interested.